Hello all, I'm Aarushi Mishra and currently working as a patent analyst with ttconsultants. Today, I will be discussing on the topic divisional patent applications. So what are divisional patent applications? Before diving into the topic, let's brush the basics. So what is a patent application? As we all know, a patent application is a request for grant of patent rights for an invention to provide exclusive rights to the inventor to prevent the competitors from obtaining monetary benefit by utilizing the invention without the inventor's permission. So it is crucial to define what is the invention we are trying to protect. As you all know, a patent application can be filed only for a single invention or for a group of inventions which forms a single concept of invention. This clearly explains that multiple inventions cannot be protected by a single patent application. Here is where comes the concept of divisional applications. If there are multiple concepts explained in a patent application and if they do not direct to a single inventive concept, then we are in a position to seek one or more divisional patent applications or divisionals. As patent rights are territorial in nature, the liberty of patent laws varies from country to country. Therefore, needless to say, the restrictions or liberty regarding the allowance of divisional applications also varies from country to country. However, in today's session, we will look at the general rules and requirements of divisional applications. We will also be discussing when a divisional application can be filed and what are its strategic advantages, etc. A divisional application is filed when a patent application has multiple inventions disclosed in its specification. The parent application will be split into one or more divisional or child applications. The divisional application can either be filed willingly by the applicant themselves or when a lack of unity objection is raised during the examination by the controller. In most of the countries, if the applicant wishes to file a divisional application, he or she can file any time before the grant of the parent application, which is the original application. Another interesting fact is there can also be grandchildren applications like a second divisional application which can be a split from the first divisional, and the second divisional application needs to be filed before the grant of the immediate parent application, which is the first divisional application. The divisional application can claim the same filing date and even the same priority date as that of the parent application. Thus, the term of the patent, which is 20 years, remains the same for the parent applications and all of the child applications. As a result, for proceedings like invalidation, the priority date of the parent application will only be considered for the child applications as well. The main consideration to go behind a divisional application is that if there are claims targeted to multiple inventions. For example, consider an invention which discloses a method of manufacturing a unique air filter for a vehicle and selective activation of that air filter based on vehicle location, weather conditions surrounding the vehicle, traffic conditions, etc., all in a single patent application. This kind of application lacks the patent unity concept. If the application contains one set of claims describing the manufacturing method of this unique air filter and another set of claims describing activation of air filter based on vehicle and environment parameters, then a controller examining this application would say that this patent application explains two inventions directed in separate ways. So an applicant would be forced to keep only one set of claims pertaining to one of the inventive concept and file the second set of claims as divisional application. The main requirement is that divisional application need to have the same specification but distinct claims set or claimable subject matter from the parent application. In general, if the parent application has multiple inventions described in the patent specification, but only one set of claims pertaining to one of the multiple inventions are claimed, then the applicant cannot file a divisional application for the other disclosed embodiments. It means the patent office may not give much scope to the applicant to scavenge the original application specification later and file divisional application for other hidden inventions in the applications. Also, if there are multiple set of claims pertaining to multiple inventions and if the applicant initially cancels a particular set of claims, then the applicant cannot file a divisional application for the cancelled claims later, as what is disclaimed belongs to the public domain or public knowledge. Therefore, it is important to keep in mind all the possible scopes of the invention and claim as many claimable subject matters as possible. Also, the controller, while examining the divisional application, will check if there are any overlapping claims between the parent application and the child application, and if there are any duplications, those claims will be rejected under double patenting rejection. However, these general requirements do vary from country to country based on their specific laws. The main reason behind the allowance of divisional application is to allow the inventors to gain maximum advantage by claiming rights for multiple inventions independently and individually. The applicant should avoid using this advantage for extending the life of the patent. The strategic advantage behind filing divisional application is that it helps the inventor or applicant to get monetary profit by granting multiple licenses for the same patent family. Also, when there are multiple divisional applications, the probability of granting certain embodiments or applications is more and thereby keeps the patent family alive throughout the term of the patent, which is 20 years from the priority or filing date. VTT consultants may help you with our patent drafting and illustration service, where our qualified and experienced subject matter experts with technical and legal knowledge develop in-depth understanding of the technical knowledge of the invention and prepare to file provisional, non-provisional, continuation or divisional applications, etc. We also help our clients in preparing office action responses for various jurisdictions. Please contact us.